talk a little bit about estate planning. What does that entail?
Well, estate planning, interestingly enough, I think the average person thinks estate planning is wills, right? What's going to happen after I die with my assets, and that is certainly a component of it. But one of the things that we've already talked a little bit about today is also incapacity, and to us that is just as important, or maybe even more important, to our clients, and they may not know it when they first meet with us, because again, they're thinking, what happens to my assets after I die? But for us, we're thinking, well, what happens to you if you are unable to manage your own either financial affairs or your own medical decision making? And so the documents that we prepare as part of a package may certainly include a will, but then we're going to add on other documents such as a financial power of attorney, such as appointment of a healthcare representative, such as a living will, as you already mentioned, Gary. Also, such as an advanced dementia directive, which is a document that we'll talk about, I'm sure. Oh, yeah,
we got to talk about that someday.
Yeah.
Someday soon. I'm intrigued by that.
Yeah.
I think a lot of people would be.
Yeah.
Yeah. Mm-hmm. But and just to go back to the kind of the death aspect, or actually the incapacity also, is that besides drafting wills for our clients, which again is the document that distributes assets after death, we also create revocable living trusts. And I'm not sure if you're familiar with that term, but basically it's a way of creating a trust that during your lifetime would allow somebody who you appointed in your document to be able to step into your shoes and manage your finances, the assets that are in the trust during your lifetime, and also to manage and distribute those after your death. The really nice part about it is that you can avoid probate. If the assets that otherwise would be probate assets that would be controlled by the will are in the trust, then you avoid the whole probate process.
And the probate process, from what I understand, is pretty lengthy.
Yep. I think on average, in Connecticut, it's about a year.
Is that right? Wow, so even longer than I thought.
Yeah.
Folks, you are listening to Legal Notes with Charter Oak Law. We're talking with Mary Ann Charron and Ned Barron. There is a difference, though, between a living will and a living trust, right? Does it have to do with taxes, or no? Am I off base here?
Well, sometimes we create trusts for taxes, for estate tax avoidance, okay? So that's one of the things for taxes. But a living will has to do with pulling the plug. So if you are in a persistent vegetative state, you are permanently unconscious, the doctor says you are dying.
And there's no chance of coming back to...
Well, I mean, we all hear about, right, those near-death experiences and things like that. But generally the doctor's like, they're shutting down. Your organs are shutting down, and you show no behavioral response. Under those circumstances, do you want to continue to be hooked up to life support? That's what a living will is. And so oftentimes people will say, yes, my children are going to keep me hooked up until the bitter end. But most people really say, if that's my circumstance, please let me go.
But there's usually religious reasons why people would go naturally as well, rather than pulling the plug.
Certainly. Everyone has their own reasons. Sometimes it is religious reasons, and sometimes it is just a personal preference. Sometimes people just want to believe in the miracle and will say that I really want to be on life support for as long as possible. So, but that's what a living will is.
As opposed to a living estate.
That's right, living trust.
Living trust.
I'm sorry, living trust. Pardon me.
You're going to learn.
I will.
You are going to learn.
Listen, this is only the pilot. This is show one.
Okay.
Yes, you're right. I do learn the lingo. If I could learn lingo on a financial show, which is way over my head the first few episodes, now I think I could go work for the company.
Right.
I kid you not, neither.
There you go.
But and of course, all right. So that's a living will because you're alive, hence living will. And then of course there's wills for when you pass. And who is that like I hate to say this way, but like a who gets what? And
that's exactly right.
Okay.
Yeah, a will really, for most people, a will does two main things. One is that it allows you to name the person who will have the legal authority to manage your assets after your death. And that person's called an executor. And the second thing that it allows you to do is to instruct the executors how to distribute your assets at your death. A third thing that a will could also do would be if you had minor children. And if so you had a couple, and at this point, both parents are now unable to be by death under a will, then they would not be able to still manage their minor children's lives. So It allows you to name a guardian to raise your children until they turn 18.
Nice.
Yeah.
You'd mentioned, you mentioned estate planning. You mentioned probate, estate administration and probate litigation. I know Marianne did elder law. You guys were both talking about that. Yeah. Special needs planning. These are real delicate, very delicate issues to be discussing.
Yeah, I really feel like this practice area is the most personal of areas because people have to tell you everything. They have to tell you if they don't like their kid. They have to tell you if there's a problem. And so special needs planning, of course, Ned and I, again, were just talking about this. I don't know what family doesn't have another family member or extended family member who isn't in some way affected or has special needs, right? And that can be obviously a cognitive disability, but it can be physical, a mental condition, could be mental health, anything like that, emotional issues, right? So we run the gamut, and a parent, there's nothing harder for a parent to figure out how do I help this child? And so a special needs trust is a special type of trust where you would able to help that child through adulthood, through their life, and make sure that there is something there to help him or her.
That wouldn't necessarily even fall under looking out after your parent. I mean, right? A special need, you could have children with special needs.
Correct. That's most of the time.
That's what you were referring.
Children.
Yeah.
Yep.
That's tough because as parents begin to age out and they're leaving what theoretically can be a 55-year-old adult with the mental capacity of a 12-year-old, and mom and dad aren't going to live forever. So where would this, I don't want to say child, this adult.
It's a huge issue.
Yeah.
Certainly in older generations, the child always lived with the parent. And then when that parent is no longer able or dies, then we have a huge issue. And Ned and I are both pretty comfortable in our practice with having to help those individuals provide housing and supportive services, and so that they will be taken care of.
And there's nonprofits out there as well, right, that are set up that ARC or some of these that.
Sure. Yeah. There are some fantastic agencies that are providing housing or
Oak Hill. I'm trying to think some of the other ones.
Sure. Yeah. They're providing housing or work, for people who are disabled.
Yeah.
One of the most important things about in estate planning and doing special needs trusts is that most people who are disabled, who have these issues, are receiving benefits from the state or federal governments, and oftentimes they're needs-based. And if they're needs-based, that means that if they have the means, then they don't qualify. Meaning, if they have their own assets, then they're not going to get Medicaid for their medical, or they're not going to get their housing subsidized, or so. And in some cases, with let's say potentially Social Security disability, right? That could also be impacted by that. So a special needs trust is a way to leave assets to somebody who has special needs, a disabled person, and still allow them to qualify for these government programs, these needs-based programs. But the funds are there to support them for the needs of theirs that are above what the state and federal governments are providing.
You're providing a lot of information, and especially as what I've just mentioned a moment ago. Estate planning and probate and elder law and special needs that you were just referring to a moment ago. I would imagine that we're going to get kind of down into the nitty gritty with these issues over the next 6 months. Before I wrap things up here, can you give us a teaser, some other things that maybe you'd like to get into over the next 6 months, other than the topics I just brought up? I only got a few seconds, but
no, that'll take us more than 6 months to talk about.
Okay. All right. No, listen, this is fascinating. You know the thing is about this is that it's not an issue that, sadly, that most families discuss. It's not a typical topic of conversation, and I think it's for obvious reasons. It's very difficult, or awkward maybe is the better word, to initiate. When? How? Who's included in the conversation? So hopefully, if anybody can get something out of this show, it's that, maybe this is the impetus for you to sit down with your family members and have this discussion. You've put it off. You've thought about it. It's been in the back of your mind. And you're like, it's kind of like that diet. I'll get to it. I'm going to do it. But this is the perfect opportunity, particularly as we go forward. I'd like to thank you for listening, because and we hope that you're able to join us each and every week, each and every Saturday morning at 7 o'clock for Legal Notes with both Mary Ann, Charron, and Ned Barron. By the way, if you'd like to reach them, very easy to do. 860-570-1229. Again, it's 860-570-1229.